topic. And before I go into a little bit about the role that I play over at the law school, I want to encourage you to fill out this quiz because that's part of the interactive learning of the session, and we will be doing the answers to the quiz in just a couple of minutes, so that will spark our discussion. Okay. Okay, great. You'll have these slides available to you. If you have follow-up questions, I would encourage you to just reach out to me by email. And I am physically located over at the law school. Now we are back in person. And in the basement of the Silverman building, the historic law school on 34th and Sansom, we have a law firm where we run 9 different law clinics, and I lead the intellectual property law clinic. We actually handle all different kinds of subject matter. That is all transactional and all focused around intellectual property. So that means that we delve in patents and copyrights and trade secrets and trademarks and privacy increasingly. And what do we do? I have third-year law students that take on clients from across the Penn campus as well as across Philadelphia, and we do all legal work for free. And so if we can help you to answer questions, or if you would like to consider becoming a client, our website is up in the slides. So as a little bit of a roadmap today, I'm going to go through those pop quiz answers, and that should give us a springboard as an introduction to some IP concepts. And then we're going to spend the meat of the session today actually talking through a hypothetical, and that will give you a chance to go into breakout rooms, meet a friend, talk through some issues, and then we'll come back and have discussion. And as Daria mentioned, hopefully at the end, we'll have a couple of moments for some final questions. Please do use the chat to put your questions in. I want this presentation to be relevant for you. Okay. So I guess I'm going to rely on the folks that are in the room to call out some answers and also tell me if people are putting things into the chat. But looking at the quiz, I've asked you to match a creation with a particular IP tool. And the tools that we're going to be talking about today include patent, copyright, trademark, trade secret, or no tool at all. So let me just ask you, let me put into the chat, for those of you at home, a manuscript for an academic book. What tool would that match with? Anybody? Or anybody here? Oh. Okay.
Copyright.
Copyright.
Oh yeah, remote copy. Awesome. Yay! All right, got three votes for copyright.
Okay, 3 votes for copyright. Fabulous. Okay, so I happen to have some information about copyright. I'm going to talk quickly about copyright and the next tool that we're going to talk about, because I want to really focus this discussion on 2 final tools. But let's talk quickly about copyright because it does come up in academic writing. A couple of things that I'd like to mention. Copyright coverage doesn't cover ideas, it covers fixed expression. And what do I mean by that? Once you actually commit those ideas to a writing, a recording, a language, then you can protect rights. So it covers things like websites, of course, manuscripts, and some software, but generally the code of the software. Copyrights last for a really long time. You get some rights just automatically. You get more rights if you actually tell the government about your creation and you register for rights. And under the CHOP patent and IP policy that we will talk a lot more about during this session, academic writings are actually owned by the author. There are some carve-outs to that, but generally the person that creates that manuscript owns the copyright to it. So points for those of you that put copyright in the chat. Okay, so let's go to product name or logo. Any ideas? Put them in the chat. Some good ones? Okay.
Wow, trademark, trademark, trademark.
Nice. Okay, the same 3 people, I'm assuming.
Oh, we got some different people. There's 4 trademarks. All right.
Very, very good. Okay. Yes. Okay. So trademarks. Trademarks are source identifiers. They connect a product or a service with a particular source. And so trademarks can actually be a lot of things that you might think about as trademarks, but also some things that you don't. So examples, names of a product, a logo, of course, so the swoosh or the M of McDonald's, taglines, just do it, I'm loving it, things like that, but also source identifiers that are kind of weird. Smells, colors. You can think about like the Home Depot orange, or the smell of Play-Doh, believe it or not. Okay, so source identifier. As long as you're using that mark in commerce, you get rights. Rights are automatic. Again, if you go through a process with the US government, you can get some additional rights by registering. In the US, it's all use-based. So you have to actually be selling a product or a service with that mark in order to get some rights. And you may not have coverage over a mark that somebody else is already using in commerce. That would cause a likelihood of consumer confusion. And so that's why we can have somebody register a trademark for Apple for computers and somebody register a trademark for Apple for daycare, because consumers are probably not going to be confused. But if I wanted to go out and register a trademark for, I don't know, Cuckoo Cola, potentially I might not be able to do that because somebody, probably a silly consumer, but somebody might be confused and think that I was actually the source of the yummy Coca-Cola. Okay, so the robotic hand, what are people saying? Okay, patent.
No, there's a question though.
Oh, there is a question. Go ahead.
Said, what happens if Apple goes into the daycare business?
Okay, if it was foreseeable that Apple could go into the daycare business, let's take a different example, like we'll talk about televisions or something like that. Somebody wants to file a trademark for Apple in televisions. Because Apple sells computer monitors, that might be not allowed because it's foreseeable that Apple would go into the business that the new person is trying to get coverage over. If Apple ends up going into the daycare business, Apple has enough money to buy off Apple Daycare. That would be my answer for that. Okay. Great. So did we get some answers for patents?
Yes, for robotic hand, patent.
Okay. Are we getting any other answers?
Someone said possibly trademark copyright, depending on how it looks.
Nice. Okay. Okay. Copyright, definitely, because you can copyright software code, and there's probably some code in here because we've got impulses back to a computer via sensing pads. There's got to be some kind of software going on in there, and so potentially copyright. And of course, you can trademark the name of any good or service. We just talked about that being a source identifier. So just looking at the bald invention, I would say patent, 100%, copyright, definitely. Whether that's a helpful coverage or not, we can talk about that. But definitely patent. Let's talk about patents. And I want to focus the rest of the 15 minutes that I've got to give this overview on patents and one other kind of IP, because I think it's most important to our later discussion. Okay, so let's talk about patents. I'm going to actually switch one more time. I'm getting a funky thing here again. It's for whatever reason. Okay, I'll just read off with here. That'll be fine.
Good.
It's yeah.
Okay.
You guys are seeing it well. I'm seeing it less well, but I'll just read off of what you're seeing, so that's good. Okay, so patents. Not everything is patentable. And just because you put a lot of time and effort into invention, unfortunately, doesn't mean that is necessarily patentable. So we get very frustrated when we really want to help inventors to patent, and we can't, but we have limits on what we can patent. So patents do cover machines, of course, but other things too, processes, formulas, plants, believe it or not, in some scenarios, and software, depending on what happens. I've already talked about how copyright can cover software. Patent is a much better tool if you can get it. It's very hard to get patent over software, but sometimes you can. We talked about patentable subject matter. Besides patentable subject matter, you can only patent something that is new across the world. So if somebody invents in France and you invent in the US, even if they don't have a patent for it in France, you may no longer get a patent for it in the United States. So patents are territorial, but prior art extends around the world. It has to be new everywhere. It has to be enabled, which means you have to have put enough research into it that you know that it is possible. And you have to be able to prove that to the USPTO. It doesn't have to be finished, but it has to be definitely possible. That's the enablement requirement. Non-obviousness is a little difficult to sort of get your head around, but it basically means that a person of ordinary skill in the art wouldn't have thought to put two inventions together to get your invention. So not only does it have to be new, it has to be like special. There has to be a eureka moment that it's non-obvious. That sounds really judgy, but it's just a legal term. Okay. Once you get that patent, it's very powerful. It lasts for 20 years from filing, and it can shut down all independent invention. What do I mean by that? If I have a patent, even if you don't know that I have a patent, and you invent something and use it, you are still infringing my patent, even if you don't know about my patent. So it's very powerful. We have what's called a first-to-file system here, which will come up in our hypo. A little hint. Meaning that the first person to tell the USPTO about the invention has the right to the patent. So if you have invented, but you keep it secret, and somebody else invents after you, and they are the one to file the patent first, they get the patent. That puts us in alignment with the rest of the world. For a long time, we were actually a first to invent system, but that just changed. Different kinds of claims in a patent get at different kinds of infringers. And so when you draft a patent, you want to think about the method, the way that you do what you do, the system, all the different parts of it potentially, the device that you've got, composition of matter. If any of these are relevant, you want to actually draft different kinds of claims, which end up sounding kind of repetitive, but they go after different kinds of infringers, and that's why we do that. According to the CHOP patent and IP policy, patentable inventions are owned by CHOP. And you can secure a license or a waiver in some cases that we can talk about later. But basically, if you invent and it is patentable, CHOP owns it. So that's different from what I just told you about copyright. Okay. Different kinds of patents. You can file a provisional patent, which does not get you any rights, but secures an early date. And as long as you mature that provisional over the first year in the United States, you will be able to get, or anywhere, you will be able to get patent rights once the patent issues. But the provisional patent is inexpensive. It happens a lot with the Office of Technology Transfer, where they start with a provisional patent first and then sort of test the market and the license market for that invention. And then you can mature to a non-provisional within a year. Okay. Let's talk about data. Data on normal range of visual acuity across child populations. In the chat, what do you think? Nobody has any idea? Nothing?
None. People said none as the.
None. Okay.
Got a I'm reading it out loud.
Okay.
Depends.
Ooh, okay, that's a good lawyerly answer. Good. Okay.
Trade secret. All right.
Okay, I'm going to start with trade secret. Let's talk about trade secrets for a second. Okay. So data is, we're in a quandary about data because data takes a lot of time and a lot of effort to amass, but it kind of falls in between some of our tools. We do talk about trade secret. Some data can be covered by trade secret. It can cover anything that basically gives you a competitive advantage and has value over your competitors. And so that can be things like formulas, business plans, customer lists, and data. So we might talk about trade secret when we talk about protecting data. Sometimes it's the only protection that you've got, because if data is not a process, then it's not going to be patentable. Copyright only gets at the expression, but if what's valuable about the data is sort of what it stands for, doesn't really get you the coverage that you're looking for. Trade secret coverage is perpetual. The only kicker is that you have to take reasonable efforts to keep it secret. And once you don't take reasonable efforts anymore, or if the data gets out, despite your reasonable efforts, and nobody has basically misappropriated it, then it's no longer a trade secret. So you can imagine it's most useful if the creation is not reverse engineerable. Somebody else can come up with it without access to your trade secret. You probably want to go to something like patent if you can. The trade secret is inexpensive, and it can be a powerful tool to keep you from other people stealing your data. Okay, so well done, whoever put potentially trade secret in there. Okay, very quickly, let's go through the last three on the quiz. How about a gene that's just been isolated and identified? Anybody?
None.
None. None is correct. None is correct. There was a case recent. You're laughing.
She was very sure of the none. None is none. Exclamation.
None. Exclamation
Yeah,
mark.
so
Fabulous.
feeling
Awesome.
certain.
Okay. Well, points to you. There was a case actually on this that basically you can't patent. Remember, I said you can't patent something that's not new. So if you just discover something that exists in nature, you cannot patent it. And there was a case on this a couple of years ago where just like identifying the gene, even though it took that lab a ton of time and a ton of knowledge and a ton of effort, just identifying a gene is not patentable. But let's talk about the next one, a molecule that's manipulated in the lab. What do you think about that? Getting some patent in there? Yeah, because you're creating something that does not otherwise exist in nature. That's the point there. And that was that whole point of that case. Okay, finally, an algorithm that runs a business process. What do you think? Potentially patent. Potentially patent. It depends on if it basically is so eureka that it takes the computer in a direction that a machine has never gone before. That's, in a nutshell, kind of the test that we have to look at here. Algorithms, you can imagine, are everywhere at this point. It may not be new anymore, what you're doing, and it may never have been new because it's just basically a mathematical process that exists in nature, and so it's a difficult test, and that's why I said that if you can get patent for software, that is really powerful, but it's hard to do. Okay, great. Y'all passed. That's fabulous. Did a great job on the quiz. Okay, so what I'd like to do, let me just tee this up. You'll see much more of this when you look at all of the chapters in the book that was described to you by Daria, and I do hope you take a look at the book. It's got so much great information from a lot of people that have contributed to it. But let me just highlight a couple of points from the chapters that I drafted. You should remember that when you are protecting as an academic entrepreneur here at CHOP, that you are guided by something called the CHOP Patent and IP Policy. It's a publicly facing document. Your Office of Technology Transfer would be delighted to provide you with a copy if you can't find it. But basically, the CHOP Patent and IP Policy describes basically who is covered under it, what kinds of things that you create that are owned by CHOP, and what kinds of things that you might create that are owned by you, and what happens in terms of licensing that out or productizing it, and what kinds of revenues would come to you and to your department, et cetera, if they are able to commercialize it or license it on your behalf. And something that I really like to tell academic entrepreneurs, you may not be the person that wants to start a CEO of your own company. And that's fine because you're busy with your day job. But your role is still not passive in helping the Office of Technology Transfer to get your great work out into the world. You can avoid disclosure, which can curtail patent rights for your invention. You can disclose to the Office of Technology Transfer through your technology disclosure forms, and that starts the whole process where basically they can help you to keep yourself from closing off your rights, your patent bill, CHOP's patent rights to your invention. You can help the Office of Technology Transfer by guiding the patent claims. Nobody knows more about this technology than you do. And so by telling them a bit about who's operating in that space, where this technology could go, what's incredibly special about it, you can help to make sure that that patent that they draft is really robust. You can tell them, as I said, about prior art. So if you know about other departments, other labs around the world that are working in this space, you can help them to do their job for you by telling them about prior art and potential licensees. If you do want to become a CEO of your own company, there is a way that you can broker a license from CHOP to take that technology and commercialize it. And if CHOP is not interested in protecting it through a patent, there's a process by which you can secure a waiver such that that technology, all those technology rights can be assigned back to you. we'll talk about this at the very end with our hapless hypo lab, but if you decide to productize yourself, your challenges are going to mimic those of other entrepreneurs, and so there are IB things that you should take into consideration.